Good evening and welcome everyone to Reach Lawyers Friday Talk series. We have called today's discussion Shortchanging the Environment because that is precisely what the central government is doing today. Today's discussion will be the second in a series of discussions called How to Kill a Law, and as the name suggests, these discussions will try to understand why there is a concerted effort at undermining important legislation. The EIA draft notification of 2020 represents a state-led effort to do away with the few remaining environmental regulations and treat the environment like a free-for-all that mining companies can exploit with no regard whatsoever for the short-term and long-term environmental consequences. But before we move on to today's discussion, I'd like to take a moment to briefly introduce to you what Reach Lawyer is. We are a network of lawyers concerned with rule of law, constitutional morality, and the future of this country. Simply put, we are a legal training and support initiative for civil rights movements, social activists, and individuals to empower them with legal knowledge. While the core of our activity revolves around our work with the legal fraternity, we also undertake various other initiatives to further legal awareness, social legal advocacy, and perhaps most significantly, we collaborate with various human rights groups and grassroots organizations across the country. To know more about us, you can look us up at www.reachlawyer.org. And with that, I'd like to begin today's discussion with a video that is inspired by a song performed by a leader of the Adivasi struggle against bauxite mining in Kashipur.
Thank you. Good evening to one and all present here. Welcome to Reach Lawyer Talk Show, part 2 of the talk series, How to Kill a Law. In the recent judgment of MC Mehta versus Union of India, Justice Arun Mishra on 13 January 2020 wisely remarked that environmental pollution or environmental degradation is a grave and blatant violation of our right to life with dignity and personal liberty. The opinion expressed by Justice Mishra holds pertinent significance in our discussion today about the recent notification issued by the Ministry of Environment, Forest and Climate Change, seeking to replace the existing Environmental Impact Assessment notification of 2006 with a new notification, namely the Draft Environmental Impact Notification 2020. Why is this amendment important and why does this call for a discussion today? It is largely because of three important changes that this amendment seeks to bring. One, that it removes environmental related activities from the purview of public consultation and exempts a large number of environmentally impacting projects from the scope of environmental clearance. Secondly, it introduces an ex post facto law which weakens environmental protection. Lastly, another significant development involves cutting down of notice period for public hearing from 30 days to 20 days, making it difficult for authorities to study the draft EIA report. In a nutshell, all these changes seek to whittle down the impact of environmental protection laws in India. So the bigger question that faces us today is, in a world where political discourses surround around the ideas of sustainable development and safe environment, are we as a nation moving back to a regressive society that pays no heed to any environmental protection and in some way undermines the right to life and personal liberty of its citizens as asserted by Justice Mishra? To discuss and contend this idea, joined with us today are eminent people in the field of environment and law. First, we have with us Advocate B.T. Venkatesh, who is a senior lawyer, human rights activist, former state public prosecutor, and the founder of Reach Lawyer, whose decades of work on defending the rights of marginalized communities, be it workers' rights, women's rights, children's rights, LGBTQ rights, human rights, and civil liberties, speaks volumes and has endeared him to many communities that are marginalized, expelled, stigmatized, and oppressed. We also have with us Mr. Sridhar Ramamurthy, an environmental scientist who's the founder of Environics Trust, an expert on mining and environment, working for decades on the rights of people and protection of environment. He has been instrumental in protecting many forests, rivers, and livelihoods of many tribals. He is also the former chairperson of Mines, Minerals, and People, a national alliance of struggle groups that are fighting for the rights of people in mining affected areas. Thank you, sir, for being with us. We're delighted to have you today. With this, we shall begin our presentation with Advocate B.T. Venkatesh. Over to you, sir.
Very good evening. Welcome to Reach Lawyer Friday Talk Show. We live in times which are difficult. We live in times of pandemic. Millions are impacted. How this came about? In fact, our fair share of the problems of pandemic stems from the fact that we have degraded our environment. Our interventions, the way we have intervened, the way we have committed the crimes on environment has caused such amount of difficulty that today we are going through one of the worst possible times of the century, the pandemic of corona. This is a time to learn how best we change. It's a time to learn how to reflect that what we have done in respect of rights are concerned, the respect of the environment is concerned. And that's something which we need to learn. All over the world, the countries, the governments are very seriously pursuing this aspect as to see how are we to change the way we function. Now, that's the thing which is putting pressure on the systems to see that how we make our changes in lives. At this time, strangely in India, we are coming up with certain laws which are detrimental to the very environment is concerned. That's the reason why that today's talk show's title is Short-Changing Environment. The recent EA draft notification that has been issued brings in such changes, as has been stated by the moderator, that would in effect kill the very purpose of the law relating to environmental impact assessment. People will have no say. People who commit the crime, the businessmen who commit the crime, can establish an industry and subsequently apply for a environmental clearance. Subsequently, they can seek payment the same penalties. In fact, if they violate the environmental, the procedures are concerned, the kind of strictures which have to be passed as against them, those aspects they can comply it by paying penalty at a later date. So the whole law of environmental protection, the whole construct of environment impact assessment, which over decades of struggle we have been able to get and we have been trying to pursue, now would be undone by this aspect. In fact, it has been very clearly said there is something called precautionary principle that is essential ingredient in respect of the environmental concerns or concern, because we are affecting not only just lives, we are affecting livelihoods, we are affecting culture, we are affecting environment, we are affecting heritage, we are affecting our water, our air, the kind of air we breathe, and the kind of lives of the people. In fact, this program is designed, presented that most of us who live in urban spaces who are unmindful of what exactly is happening in that part of the country that produces our electricity, that part of the country that secures us this clean water, that part of that country which gives us all the facilities which we enjoy, be it grain or any aspect. Today, that country, that part of the country is going to be impacted so badly with this energy. We have seen in Karnataka the kind of devastating effect that it had in Bellary mining is concerned. We have seen in parts of India how the degradation has impacted on the forests, on the ports, on the coast of this country. We have seen this happening. We have seen the kind of crimes that we have committed over a period of time on the environment. Right from Bhopal gas tragedy, what have we learned? Have we learned nothing? I think that seems to be the way these changes which are being brought to this law. I am not delving on these aspects for a specific reason that we have today one of the best experts on the environment and the climate change that's happening across. He has been working for decades on these issues, and he has been an amazing person who works with the communities, has been helping communities, reaching out to communities, trying to mitigate the situation, trying to agitate for protection of environment before all the fora. There is huge number of portfolio of litigation as against major companies across India before the Supreme Court and before the Import Committee and also before the National Grains Tribunal. This activism of Mr. Siddharamurthy makes him someone special, well informed on the subject is concerned. Today he is with us. Before we go into it, we request that you to watch the two short videos of this alliance called Mines, Minerals and People. Mines, Minerals and People is a national alliance of struggle groups, of more than 250 struggle groups from length and breadth of this particular country. Nearly 28 states is represented in this particular organization, where the people who are affected by mining, whether it's greenfield, whether it's a place where mining is ongoing or where the mining has been abandoned, all these areas, how it has affected the lives of the people, how it is affecting the lives of the people, livelihood of the people, culture of the people, the kind of crimes that are being committed as against them, all those aspects are being understood, agitated, fought for in various groups, and we provide a kind of support. The Mines, Minerals and People provides a kind of support to these groups. This alliance has its one of the finest footprints across this country, and they are agitating this draft notification on EIA, say that this is going to be really killing the whole law of environment protection. This is going to kill the very law relating to environment impact assessment. In fact, this is also going to give kind of license, freedom to the polluters, license and freedom to the persons who want to pollute the environment, who want to destroy the environment, destroy the livelihood, destroy the culture, destroy the heritage of this particular country. I think this is something which we need to be concerned. So these two short videos of Mr. Ashok Shrimali and Mr. Ravi Bapragada. Ashok Shrimali is General Secretary of the Mines, Minerals and People, and Mr. Ravi Bapragada is the chairperson of Mines, Minerals People, and National Alliance for working for the mining affected communities who have been fighting for these environmental issues and protection of the lives of the people. Thank you.
Good morning. My opinion about the EIA draft 2020 is actually very simple. They have done away with the precautionary principle, and for any environmental legislation, it is based on the precautionary principle. And so, in that sense, the EIA draft is basically as good as not being there. I mean, there's no act as such, no control, no monitoring. So, therefore, it's a very regressive move by the government of India, and this should be withdrawn. Thank you. Good morning.
पहले जो पर्यावरण आकलन में जनसुनवाई की जो बात थी और जनसुनवाई जो होती थी, उस जनसुनवाई में प्रभावित समुदाय, किसी भी प्रकल्प से जो प्रभावित समुदाय है, वो प्रभावित समुदाय अपने आर्थिक हितों का, अपने सामाजिक हितों का, अपने सांस्कृतिक हितों का, अपने जल, जंगल, जमीन और खनिज के हित में और अपने पर्यावरण बचाने के हित में वो पूरी बात को रखने का अवकाश था, गुंजाइश थी। अभी क्या हुआ है, इस नए समाशोधन में कोई भी प्रकल्प को बिल्कुल अनुमति मिल जाएगी और अनुमति के बाद जब जरूरत लगेगी तब ऐसी जनसुनवाई होगी। तो लोगों की आवाज दबाने की बात है, लोगों के जो कुप्रभाव होगा हम समंदर पे कुप्रभाव होगा, हमारी नदियों पे नहीं है। विकास की अवधारणा को पर्यावरण के अनदेखी करके हम नहीं कर सकते। हमें हमारे आने वाली पीढ़ियों को, हमारे बच्चों को एक सुनहरा भविष्य देना है, तो पर्यावरण आकलन करने की एकदम आवश्यकता है। धन्यवाद।
Now to present, we will have Sridhar sir, who will talk to us about the evolution of EIA and the impact that the new amendment notification has. Over to you, sir.
Good evening, everybody. Thank you for inviting me, and all the best to Reach Lawyer for the valiant efforts during this period when there's lockdown, not only to educate people on the kind of issues, but also to take up some of the most crucial aspects of the country's life today. So I've been associated with the work that BT Venkatesh and the team has been doing over years, and have hold it in very high respect for the kind of uh, support that marginalized communities can always rely upon. Uh, Getting on to today's discussion on the environmental laws in India. Before independence and until 70s, most of the country's environmental aspects were largely governed by the forest law, the wildlife law, and even forestry was more, how to harvest timber. It was more a silvicultural law and law of exclusion of other people. And also, a lot of thing was taking shape in terms of public nuisance or tort laws. Uh, Even where a lot of people keep saying about 33% of the land has to be under forest for environmental reasons. But this is a part of an agricultural policy of 1951, which said that for a country like ours, because there is an intimate linkage between how farming happens and forest sustains this farming, we must have at least a third of the land under forest. But in terms of modern environmental governance, uh, somewhere in the 70s, early 70s, especially when the Planning Commission took some interest, and as a what is now seen as a preparatory effort to the Stockholm Conference in June 1972. Even before that, a National Committee for Environmental Planning and Coordination, NCEPC, was formed, and they started working on enunciating the Air and Water Act, which many of you know came in by 1974. The composition of the NCEPC was one with people with extremely high credentials, and the project appraisals they undertook involved a substantive inquiry into the environmental setting of the project, its possible adverse effects, both on environment, on the communities, people who are dependent upon it, and their recommendations were very highly credible because of their transdisciplinary approach. I can give you example of projects like the Silent Valley project, the mining in the Gandhamardhan Hills in Orissa, and where uh, the committee itself said the Silent Valley hydropower project or the Gandhamardhan bauxite mining project would be more harmful, and therefore this should not be allowed at all. So there was an understanding that we should begin to understand this, and it is not focused on one discipline. Similarly, there was another project where today we find the project has come up, but where they invited Dr. Salim Ali, who many of you know was a renowned ornithologist, to look at a fertilizer plant to be set up in Avasheva, and the they said that if pollution, if the pollution control equipment ever broke down, then it would impact not only the fauna, flora, and other things, but it will impact a lot of people in the urban areas around it, and therefore it should not be taking place. But the government did go ahead with it, and the fertilizer plant came up, not in the private sector, because originally it was thought to be in the private sector, but they said, under a public sector, it might be a little more carefully handled. So this existence of the NCEPC led to, one of the decisions that it said was the issues were wide, and it demanded the creation of a separate Department of Environment in the Union government. And therefore, a Department of Environment was created in 1980, which would then had the role of dealing with the Air Act, the Water Act, and the old Smoke Nuisance Act, and also to study about wetlands, what to do about them, and also look at how to spread environmental awareness and research in the country. The department's mandate to spearhead the role that environmental conservation must play for national sustainable development led to the merger of the Forest Department, which was operating under the Ministry of Agriculture, into this full-fledged Ministry of Environment and Forests in 1985. So the Department of Environment and the Forest Department, which was a part of the Agriculture Ministry, was brought together as the Ministry of Environment and Forest in 1985. Many of you would remember and recall, that 1984 was very, very bad for the Indian environment, and particularly for people living in Bhopal, when we had this Bhopal gas tragedy. And even today, some of our friends continue to work, and some of our friends continue to suffer the implications of that disaster. This provoked the government that we must have a more stringent law, and I was fortunate to be able to participate in that process when this new law was being formed by providing to the government then literature that was available across the world, which also enabled me to learn about the process. And the Environment Protection Act came up in 1986. Though the Environment Protection Act came up, the rules, the specific notifications were still being formulated, and this was a period, I would say, when we compare to what the proposed legislation is, I would say that this was the golden era of environmental impact studies in India, or environmental assessments in India, between the period when the NCPC was formed and 1994, when the first environmental impact assessment notification came up. Because during this period, as I mentioned earlier, one was everyone recognized that environmental assessment and understanding environmental impact is a multidisciplinary or even transdisciplinary area of study and research. So, like one of our famous, kind of scientists in India who went on to do some amazing agricultural experiments, Dr. P.R. Mishra, used to say that, the whole idea of what happens when soil and water mix, the soil scientist and the water scientist started thinking together. What happens when a particular composition of air of chemical goes into the air, and how does it spread? So this required disciplines of different nature to come together. And so there were a lot of interesting studies, and I would younger people who are there in the meeting, I will request, provoke, whatever is in my command to kind of encourage them to look at literature that has been developed in the country during this period on how environmental impact assessment was done. And we used to have even good, interesting workshop on what used to be called as the adaptive environmental assessment processes. However, since the EIA notification came up, and there was a change in the attitude both of the promoters of industry and the bureaucracy, where it became a matter of approvals. So many of you wouldn't know that there were methods like the Leopold interaction matrix, which had 64 elements, you know, uh, of likely impacts in each of the context of the project. And it used to be prolonged studies. It was not that they had to do it. And now in the recent times, the rapid EIA, which is done in 3 months, which does not tell you anything about the environment in the area. So from very complex kind of studies, it slowly became a process which was more focused on how to get clearance. So along with that came bribery, various other things that at one point of time it was called a Jayanti tax or a Javadkar tax and things like that. So what are the pitfalls in the current process which already exists, and what it is that the new 2020 EIA notification is bringing. So before I go into the pitfalls of the current process, what I want to also highlight, because I think several of you are young lawyers, is this hierarchy of the legislative process. Like one would normally think that an office order or a notification is not a very important legislative activity because it's a subordinate law, or less than a subordinate law, because it's not also rule making, it's only a notification under a law or a rule. However, the manner in which the government deals with it is sometimes the office order overpowers or is implemented more vigorously than a notification or a rule, and a rule takes greater significance than a law, and the law takes a greater significance than the constitution itself. So while one could keep debating on the constitutional aspects of what happened with Article 370, it was merely kind of an office order or a notification that kind of eradicated the protection that we had in J&K. So I think this is something that a lot of lawyers need to seriously think about, and especially when it comes to environmental assessments, especially when it comes to issues of natural resources, because what we inherit is not from our past generations, but I think we have taken already both minerals, forest, everything from our future generation. So we need to be even more responsible about it. Like we constantly talk about the precautionary principle, and also the whole concept of sustainable development. So we'll look at towards the end. We probably can, if time permits, we can explore the idea of sustainable development, because many of the Supreme Court judgments and the Green Tribunal judgments allude to sustainable development as a priority principle or process by which we should kind of see many of these kind of decisions. So what are the kind of pitfalls in current processes which are already there? So the first kind of pitfall is generally there is no proper scoping, which is resulting in a flawed rationale for the project. So should a project exist? Is a project really necessary, or is there ways to we have several projects where the need for that project is questionable ab initio, right? Like for instance, like the current one of the current cases and campaign that is going on is a project of a thermal power project in the Godda district of Jharkhand, where coal is supposed to be mined in Australia, and will go around the Great Barrier Reef, come to Dhamra port in Orissa. It will demand an expansion of Dhamra port, which will impact the nesting sites of the olive ridley turtles. Then from there, it is going to be brought to Godda, which is about 800 kilometers into Jharkhand, and the power is going to be produced, and then the power is going to be exported to Bangladesh. And this government has actually granted a SEZ status to it. And this SEZ status has been granted post facto, means after they started construction and activities took place, then the government, gave the sanction that it should be treated as a SEZ, particularly because they were not able to, both the government and the industry was not able to answer several questions relating to land acquisition, questions relating to environmental processes, public hearing processes. So they wanted to circumvent and said this is the first energy SEZ in the country. Now, whether this project is required at all, uh, if you look at the current power generation status in India, we are having excess power capacity. We have close to about 40,000 megawatts of power projects that have been created but not used. Then of the existing projects, when we look at plant load factors, that is only 45 to 50% of the load of the plant. If a power project can produce, say, 100 megawatt, it is only producing 45 megawatts because there is no demand in the country. So do we need a project? So the scoping is not done properly, whether the project is needed at all. There are several damaging projects. Closer home, you will know the Gundia hydropower project. I've been talking about the Renuka project, which is also a matter of our litigation, where this dam, which is meant to submerge some 37, 38 villages, is meant exclusively only for drinking water for Delhi. So whether Delhi can improve upon its habits in terms of how it uses its water and what amount of water goes into drinking. These are questions are not asked just because it is Delhi and we can demand for more water. We are starting certain kind of projects. The second is there are second flaw is there are several alternatives that exist which simply are overlooked. That is, I'll give you a different kind of an example here. We have certain kind of in the beginning you heard about the kind of bauxite related campaign and the protests and successful protection of those areas in the Eastern Ghats by Samata, MMP. Now, what you find is we have certain few deposits, like one of the deposits is in Panchpatmali where NALCO is already mining, which has close to about 700 million tons of bauxite. And this area has been opened up. Now, do we use all the bauxite from this area for our aluminium production? Or do we open up small pockets like, the big protest that happened in Niyamgiri with the bauxite mining of Vedanta there, or what is now happening in other parts of Orissa, or very small deposits that are in Western Ghats in the Ratnagiri area. Do we need to open up these small areas and create patchiness in forests and then lose lot of biodiversity? So this kind of alternatives that exist for that material, that kind of thing is not taken into consideration. The third kind of drawback we have is a poor quality of assessment. As I said, between 80 and 94, if we call it the kind of golden period for environmental assessments in India. As we have come down, in Tamil there is a proverb, "Kaludha tenji kattarum vachal." Like what has happened is the quality has deteriorated over a period that now even the assessments, for instance, the terms of reference says that you need 104 data points for air quality. So it may tell you about the air quality or not, but most assessments are based on very minimal data and provide very little understanding about the real impact of the project or activity that is being proposed. It's not only poor quality of assessment, it goes along with poor quality of appraisal. For instance, just it was a very big struggle for us, and it continues to be a struggle for us, that the number of projects that were taken up for analysis in an appraisal committee meeting at some point of time were so large that it was like what I would say, even for, it was impossible even for God, because they granted 410 mining approvals in the first 6 months of 2009, and which meant that like every month each member is studying some 40 environmental impact assessment reports. Each one of them may be 300 or 400 pages. So it meant that almost on 24-hour basis they must have been reading this, and also that these appraisal committee members were not people who were just doing this task. They had a daytime job. So the quality of appraisal has also over the years been completely kind of undermined. Then the other flaw that I noticed is the cumulative impacts of the project is generally not considered. You're saying that I set up one more industry. This is how my industry pollutes. But whether that industry is located in an area where already there is a significant level of pollution, that is not considered. Also, various elements of a project. For instance, I was mentioning to you about this thermal power project in Jharkhand. The appraisal for the thermal power plant does not include the fact that there is a water pipeline and a water intake point that has to be built in Ganga. What happens to the impacts on the Ganga river when you take out some nearly 36 to 40 million cubic meter of water each day? Then what happens to people who are on the railway line? What happens to people who are dependent on the farming in that area itself? What happens to fisher folk in Dhamra where you are expanding? So this kind of a cumulative impact of a project is never undertaken. Then the other flaw which I find is where there is a poor history of compliance of the same kind of a promoter, but you allow them to continue to do the project, or continue the same promoter is doing a project elsewhere. And there can't be a more classic example than the Vedanta group. All of us know of what the Tuticorin copper smelter project, and the huge protests and firing, people dying for it happened. But Vedanta is being given cleared more projects, and in the most recent kind of coal auction, he was the other speaker along with the Prime Minister of India, saying that Vedanta group thinks that bauxite mining lease, coal mining lease, and all of them should be clubbed and handed over to him. So what we are finding is there is no deterrence for a person who is who is going to, and now there is new kind of changes that are brought with that post facto kind of clearance. You don't need even to be questioned on these things. Then the other problem I notice with the current process itself is the sequence of the clearance. For instance, while we are trying to understand the environmental and other impacts of the project, in the meantime, the promoters acquire the land, and then once the land is acquired, rest of the consents are manufactured, and or they are bought out. So even like even after a judgment in the Madras High Court several almost a decade ago, that no, you should not start land acquisition until environmental and other clearances and objections from the people are considered before issuing the notice for acquisition of land. It is generally done the other way, and rest of the clearances are obtained as fait accompli. Then the other kind of flaw is that industries known to be hazardous and banned across the world are continuing to be produced, whether it is the kind of dangerous agrochemicals and pesticides that are being produced by Syngenta in Goa, or the asbestos products that are being produced across some 100 odd factories in India. These are known hazardous materials, and people have moved out of it. But our country, and it's very ridiculous in the context of asbestos, where in 1986, as I said, the golden period of environmental assessments in India, the government of India banned asbestos mining. But we import 100% of our asbestos and kill our people today. So, so these 7, 8, 9 things, which I listed out, are what I think are the kind of fundamental flaws of the existing system. I'm getting some disturbance. Is there some question or something that somebody wants to ask, or it's only that some mic is on?
No, sir. So mic was a problem. You can go ahead.
Yeah. So as I said, so there were significant flaws in the existing system. So one would expect that when a new notification is made, ideally what happens, like if you find a leak in your bucket, the first thing you will try to do is how will you fix that leak. But here is a situation where we know that there are these kind of flaws, but our government is trying to expand the leak in the bucket. So what are those disturbing trends that have taken place in the last 5-6 years, and especially from 2014, though there were attempts to dilute even earlier, but a very, very clear trend exists from 2014. This government took charge in May 2014, and it promptly set up what was called a high-level committee. The high-level committee wanted to do a wholesale change in all the environmental laws, and it said that we must leave it in absolute good faith of the of the promoter, and we shouldn't trouble them too much, and we should form a national environmental management agency and a state environmental management agency, which would be the institution which will deal with whatever consequences this will have. It was to the extent that some of the mining companies went to the government saying that the task of mine closure or would also not be theirs, and they would mine their mineral and walk away. And uh, and they thought that they will push this through. It was the TSR Subramaniam Committee report. You can look at what that report was trying to do. And but fortunately for the environment in India and for many of us, the Parliamentary Standing Committee, which had a lot of people in the Rajya Sabha, and the Rajya Sabha uh, was not under the control of the ruling party, and therefore this report got rejected. Said that like the report, there was no reason for hurrying up all these changes, and so this kind of wholesale dilution could not take place. So the government started then to do this in a piecemeal manner. So the first kind of attempt was to remove the construction sector from the purview of environmental scrutiny. So what it said was, like under the notification, EIA notification, any construction project which has more than 20,000 square meters of footprint needs to be, undertaking a EIA, and also should have consent to establish and operate under the Air Act, Water Act, and concerned people could challenge the clearance or the the establishment of some such kind of things with the Green Tribunal. But what the government tried to do in 2016 was that it said that it will exempt all projects up to 150,000 square meter of built area, which meant that most of the buildings, or like 150,000 square meters would be more than 3 acres, or much more than that, like so very large construction projects would uh, would go out of the purview of the EIA. So this was also litigated in the Green Tribunal, and what was said was that like you could not change this kind of a thing, and the tribunal had very strongly reprimanded the ministry for looking its own, because there were findings of the ministry itself that the idea of making the municipal corporation or the development authorities which give you clearance for building construction to look at the environmental aspects also would be regressive, and they couldn't do it. They lacked the competence in terms of uprising what environmental implications it would have. Despite this, the government has now again moved it to 50,000 square meters. The third kind of thing is a very clear, what I call impunity in the highway sector, where what it did was it said that any road project which is less than 100 kilometers doesn't need a EIA. So what it meant promptly, and which the latest, decision and the Chardham road has also been, is that the government promptly found ways, and especially the National Highway Authority found ways of breaking each of the highway project into sections which are less than 100 kilometers. So to do away with all the due diligence. One of the classic examples which we have been litigating, and which has taken very bad kind of direction, is the road from Chandigarh to Rohtang, which when they initially gave the proposal, they said it's a very strategic road, right? And this word strategic, whenever the government uses it, means that you shouldn't ask questions. And what it did was it broke down this road into segments like Chandigarh to Kiritpur, Kiritpur to Nerchok, Nerchok to Mandi, Mandi to Manali, Manali to Rohtang, and gave the contracts to different kind of companies, because they have been outsourcing this kind of an activity. They went to the extent of denotifying the Govind Sagar Wildlife Sanctuary, which was the area of the Bakra Reservoir. And today we know how fisher folk in that Bakra Reservoir are suffering because of the muck that is dumped by this road expansion. Similarly, highways passing through national parks, sanctuaries, these kind of things has been allowed much more easily now. And also what we are finding, and this is again something for lawyers to consider, that I used to think that this was mostly happening in the Himalayas, but across the country, especially on highway projects and all linear projects like pipeline, transmission lines, most often the promoter and the government is not very diligent. So what happens is the actual plan and acquisition is in one area, and or in many places there are discrepancies that the land, the clearance is for one area, and parallelly somebody else's land or buildings are being affected. So the people who are affected do not get any compensation for it. Similarly, many of you know that there has been effort to dilute the coastal zone regulation, and many of it is happening because of the how they classified the coastal zone into a variety of zone 1, 2, 3, 4 of that kind, 4A, 4, 3B, like that. So you complicate the way in which you you deal with an area, so that nobody knows what is actually to be done. And this whole Sagarmala project and its implication to fisher folk, I think it's a matter of a complete session that we should think through. Similarly, the other kind of thing that this government tried to do was dilution and destruction of the institutions governing wetlands. And many of my colleagues and friends in Reach Law would remember that we did a workshop in Bangalore also, apart from several other places, on the dilution of the wetland rules, and how in the name of redefining how wetlands are defined, that itself enabled dilution of this kind of concern of the environment, how the Central Wetland Regulatory Authority was being dismantled, and lot of the requirement under the environmental impact assessment, which was mandatory, and the list of prohibited activities, all these were kind of deleted. The other kind of dilution dilution or the attitude that we have seen is that it's more like an ostrich-like attitude, I would say, because there was a judgment, an order which said that in 2015, that because of the pollution of coal-based thermal power plants and it becoming high, many of them all of them have to have more stringent pollution control measures, and also should have technologies that can control pollution, like the uh, uh, gas disposal, FGD systems. Uh, the While environmentalists raised these questions and the case was going on in the Green Tribunal, uh, they were supposed to do it by December 2017. And until 7th of December, in the Green Tribunal, the government unabashedly maintained that the government was and the ministry was very serious about implementing it, and it will close down or it will have very strict measures on it in the Green Tribunal. But what it did, that it very surreptitiously went back to the Supreme Court to seek extension up to 2022. So finally, what I would like to say is many of you should look at a site called esubida.gov.in, which has been, which is the Prime Minister's office maintained project monitoring group's website, which pushes for these projects. Currently, more than 1,000 projects are there, and as the last couple of days news items are coming up, the World Bank itself has been giving up on the ease of doing business index, which is kind of rigged, and India is trying to improve upon its ease of doing business index, but it is 177 still in about 180 countries in its environmental performance index. So therefore, I think it is time that we perk up our environmental systems and do not allow for these dilutions to happen. And I'm sure many of you would have good ideas and on how we'll deal with this future that seems to be very, very seriously staring at us. Thank you very much.
Thank you, Sridhar. Thank you, Sridhar. So we need to know some aspects which I would like to add. All of us have concern for our environment. We have brought in changes in laws. We are signatories to a number of international agreements, treaties, Rio Convention, Paris Convention, you name it, Kyoto Protocols. Many of these things were signatories. We have diligently brought in a number of statutes to protect environment. We have also suffered that amount of impact on the environment, whether it is Bhopal gas tragedy or so many things that's going on even as on this day. Any given day, you read a newspaper, you find an issue of environmental degradation causing harm to people. This is something which all of us know. And all of us are also equally concerned regarding the same. So when these laws are made, these laws are supposed to ensure compliance. These laws are made to ensure that suitability of an industry in a particular area. These laws are made to ensure that if there is anyone who is violating while undertaking an enterprise, that he need to comply, that he need to follow, he is penalized, his operations are stopped. There are so many checks and balances and the regulatory mechanisms that are employed to ensure that the environment is protected. Protecting environment is not just for us. Protecting environment is for the entire flora, fauna, the kind of populations we live, the rural atmosphere, the kind of rivers we have. Do you know, I would like to say one thing, that do you know there are number of dead rivers in India? You may say that, how can there be a dead river? Yes, there are a number of dead rivers where water flows. They are dead in the sense that there is no oxygen which is there in the water that will support life. There is so much of heavy metal in the water that makes life impossible. Or that if anyone consumes, perchance something survives in that water. If someone eats that fish or eats that meat, he is going to be facing serious health issues. So when you look at this, we are concerned. So therefore, we have brought in all these laws. So when we have all these laws being in existence, there have been serious efforts to scuttle the impact of these laws. In fact, the corruption which exists in our system, the way the environmental impact assessment reports are manufactured many a time with absolute impunity, the way the authorities turn a blind eye for violations, turn a blind eye relating to transportations. We have seen that in Bellary mining scandal, that the kind of violations that take place there are existing laws which are there to protect. It was because of these laws, because of these existence of these laws, that there was a possibility of prosecuting these industries. Now, when the agencies of the state, when the public spirited persons are concerned, just look at the kind of laws, judgments we have in Supreme Court. Umpteen number of judgments are there in Supreme Court and High Courts of India, wherein people, citizens like you and me, come to the court, agitate. The tribals come and agitate. The civil society comes and agitates, saying that this is unacceptable. The series of MC Mehta judgments, the series of judgments going towards the protection is concerned, that we have seen that the courts have come as against protecting the environment is concerned. So we have this. In fact, our moderator presented in the beginning Justice Arun Mishra's statement in January 2020. Now, when we have such situations, we see that there is systemic degradation of the entire law also, not only the environment, degradation of the law also, that also goes towards bringing in certain changes in notification through such notifications, which virtually kill the very purpose for which these laws are made. In fact, there is one statement which goes to show what Supreme. We say in our Constitution of India that we have very clearly stated, right to life. Supreme Court has said umpteen number of times, right to life means right to a clean environment as well. So when we sit here in urban spaces, when we sit in places which are comfortable, we need to be concerned, because any impact on environment will affect us too. It will not be that someone else is getting affected and we pay for it. No, we are not paying for it. There are people who are paying heavy price for it. I'll give one simple instance. When look at enjoy air conditions in our houses, comfortable situation in the houses, the kind of ash pond in Hazaribagh district we had an opportunity to visit, the ash pond of a power plant goes down, percolates, the sulfur and the lead in the thing percolates into the ground, impacts the groundwater, and the tribal communities which live in the adjacent area, they have skin issues, loss of hair, abortions, cancer, and you find them with one of the dirtiest possible skin rashes. Why? Because the company which produces the power has no respect for the law. We don't question that company because we say that we have paid the money, we pay the bill. So therefore the payment is made by us. But actually, who's actually paying? That tribal who is facing that kind of health hazard. That tribal who is living in extremely difficult conditions. And interestingly, all the power that is produced in that particular factory, the power plant, comes to us. The tribal continues to live with his kerosene lamp in the hut. There's no more than that. Now, we live in such country. There is a need that environment need to be protected. It should be our concern too. It's our mandate, it's a duty that's cast upon us. That's what Constitution of India says. Protecting the environment, Constitution of India says it's a duty. Communities' control over natural resources should be our endeavor, says Constitution of India. It's our duty. But the kind of successive governments to scuttle the whole processes, make environment a subject of business, that we don't care about environment because we look at money, we look at opportunity. In fact, Mr. Sridhar was telling the 1,000 projects in pipeline in Prime Minister's office, seeking clearances. And the kind of clearance that is happening, the number of questions, a number of environmental groups, organizations, individuals have filed huge number of petitions, the number of petitions pending before the National Green Tribunal and before the Supreme Court, all the other high courts, challenging that these reports are faulty, challenging that these reports are manufactured, challenging these reports are made which do not reflect the reality. Now, when such situation exists at this point of time, this notification which is being introduced is virtually giving a blanket opportunity for anyone to start an industry in a particular area, because today we have industrial areas designated for particular industries. So if he is starting an industry in that particular area, he can start the industry, acquire the land, put up the factory, and then subsequently can seek clearances from the government. And if at all the violations are there, he can pay a penalty. The way the whole law is being diluted makes this whole process of protecting environment a joke. And today the government does not seem to have any interest in protecting the environment. In fact, though it talks of that particular language, the whole set of rules that come under EIA, every one of us need to read them. Every one of us need to understand them, because it's our environment. It's our life. It's not somebody else's life. It's our society, not somebody else's society, that we are to be concerned. We are responsible not only for our consumption, we are responsible to our future generations. In fact, that's what Mr. Ashok Shrimali, General Secretary of the Mines, Minerals and People said. What are we leaving for the next generation, future generations? Do we have any responsibility towards that? I think that's the kind of question that we need to ask ourselves before we turn a blind eye to such kind of notifications that are being brought in by the government. This notification should go. These notifications are to be protested by each of us. All of us need to discuss, talk, debate. There are ways you can protest. There are ways where you can send by mail, by email, by WhatsApp, by a petition to the government, making your statement clear that we don't want that kind of change. Every one of us need to do that kind of a change. So therefore, there is a need that this dilution should be stopped. This dilution of rights, the kind of laws that are being brought in, need to be stopped. This draft notification affects environment so badly that our lives, your lives, and lives of so many millions of this country is risked because of these changes. Thank you.
Thank you, sir, for your elaborate explanation and details of how the evolution of EIA happened and the cumulative impact of it. Thank you for taking us to the thermal power projects and the impunity sector. A statement that particularly intrigued me was the ostrich-like attitude that sir specifically spoke about. Thank you, sir, for the elaborate. Thank you, Venkatesh, sir, for taking us back to ground realities and telling us about how in everyday lives we tend to turn a blind eye to things that don't matter. It is only my appeal as a law student and as a responsible member of the society. Let us not encourage a law that undermines livelihood, that undermines and it completely belittles the efforts that have been taken by environmental activists like Sridhar sir to come up to a point where environment could be protected, and now all the efforts have gone in vain. With this, we'd like to conclude today's discussion with a clip from a documentary, Mahua Memoirs, on devastating effects of mining. Thank you everyone for watching.
Thank you.
Yare Hatone Ivaru Arero Dagata Bajugu Buravani Bela Vahimane. Allora di Buravani Calariba, oh Vahimane diretone. Roye eba dara roye, bobo roye eba bono roye. Yalla hendu hendu re labra hada punjava hamaniyo. Allo labra gina punjava hamaniyo. Kena dide besa manne tosa manne. Oh, the stati budina